declare open this hearing of the Senate Community Affairs Legislation Committee inquiry into the Social Security and other legislation amendment, technical changes number 2 Bill 2025. I begin by acknowledging the traditional custodians of the land in which we meet and pay my respects to their elders past and present. I extend that respect to all Aboriginal and Torres Strait Islander people here today. The committee will be conducting today's hearing via video conference and in person. I am Senator Dorinda Cox and I am the Chair of the Legislation Committee, and I have with me online Senator Ormond Payne, who is the Deputy Chair of the committee, Senator Ananda Raja, Senator Brown, who is in the room in Canberra with the Secretariat, and Senator Collins. These are public proceedings being video live streamed via the Parliament's website, and a Hansard transcript is being made available. I remind all witnesses that in giving evidence to the committee that they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action should be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. Witnesses also have a right to request that they be heard in camera. If a witness objects to an answer to a question, they should state the grounds on which the objection is being made, and the committee will determine whether it will insist on an answer having regard to the grounds in which it is claimed. The committee determines to insist on an answer, the witness may request that the answer be actually given in camera. I remind all senators of their obligations under the Behaviour Code for Australian parliamentarians to treat witnesses with dignity, courtesy, fairness and respect. And I remind committee members and witnesses who are appearing via video conference who are not speaking to mute their microphones. I now welcome via video conference representatives from the Australian Council of Social Services, Anglicare Australia and the National Women's Safety Alliance. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to the Senate committees has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear today? I will now invite each organisation to make a short statement, and at the conclusion of any remarks, I will invite members of the committee to ask questions. I think we'll go to ACOS first. No? They're not here with us yet? Are they in the room? Sorry.
Oh, am I unmuted now?
Yes.
Okay, great. Thank you so much, Chair, and can I also pay my respects to First Nations people. Today I'm coming to you from Gadigal land, and I extend that respect to First Nations people on the call. Yes, look, my name is Charmaine Crowe. I'm the Program Director, Social Security at the Australian Council of Social Service. And we very much welcome the opportunity to provide evidence with respect to the legislation that's before the committee today. Look, this bill does a lot of good things, and we're very pleased to see the government implement reforms, particularly with respect to debt waivers in the Social Security Act. These reforms are long overdue, and I congratulate organisations like Economic Justice Australia and Single Mother Families Australia, I can see Teresa's on the call, for their long-term advocacy to improve debt waiver for women experiencing family and domestic violence. And, you know, it's very important that the government has commenced implementing reforms to debt recovery, and we urge the government to go further, including by putting in place the 6-year statute of limitations on social security debts. We also warmly welcome the government waiving the 1.2 or around 1.2 million undetermined small social security debts. Now, with respect to the income apportionment component of this bill, look, we appreciate that the government has a very difficult problem before it to resolve. Successive governments have unlawfully calculated people's fortnightly social security entitlements for several decades, which has resulted in up to 5.5 million debts being incorrectly calculated. In addition to that, we don't know what the effect was on people's income banks that were incorrectly tallied, or the extent to which people lost other payments because of income apportionment. We also don't know how many people paid recovery fees that were higher than what they should have been on inflated or indeed false debts. And we still don't know the full effect on criminal convictions where debts were income apportioned. And we note that this bill doesn't address that very serious issue. We appreciate that it would not be a wise use of government resources to recalculate people's debts, even if there were or was the available information to do so. However, we think that the resolution scheme that's currently proposed will fall short for a lot of people, even though for others it will be sufficient or indeed provide a higher amount of compensation than what they would otherwise be owed. We've recommended that people who are owed a higher amount than what the resolution scheme provides be able to get that amount at the very least, and that process be straightforward. Look, finally, I close by highlighting that this is one of several cases of the government unlawfully administering the Social Security Act in a systemic fashion. Social security payments are a lifeline, and it's completely unacceptable that successive governments have failed to follow the law, which has led to people having their payments cut or cancelled. Given that social security payments like JobSeeker fail to meet basic costs, there's simply no excuse for any government to further diminish those payments through a failure to follow the Social Security Act. Thanks so much, Chair.
Thank you so much, Ms Crowe. I think we'll go to Anglicare Australia.
Thank you, Senator. I would also like to acknowledge that I join you today from the country of the Ngunnawal and the Ngambri people and pay my respects to their elders past and present and extend those deep respects to First Nations people on the call today. Each year our network supports more than 596,000 people across every state and territory in services such as financial counselling, emergency relief, mental health support, homelessness services and advocacy for people who rely on income support. As a network that works for and with people on the lowest incomes, we have advocated consistently against the system that became known as robo-debt and remain actively involved in consultation and advocacy related to the scheme. We have been very pleased to see the ongoing work of the Albanese government to pursue policy and legislative change that works to correct these historical wrongs, and as such we welcome many aspects of the bill which seeks to reform the debt waiver provisions. However, this bill fails short of upholding complete fairness for those who've been affected, and we feel it must be strengthened to provide genuine resolution. As stated in our submission, for decades people have been burdened with debts that were incorrectly calculated, with some overcharged, others pursued for debts they did not owe, and many more losing access to entitlements they would otherwise have received. That goes without talking about those who lost homes due to inability to pay rent, those who came up against criminal convictions, and those who came in other ways harmed due to having income removed. While the resolution scheme proposed in this bill recognises the problem, we feel it does not go far enough to put this right. The proposed scheme places strict limits on what people can recover, with the compensation capped at $600, regardless of the size of the debt or the losses people experienced. While we recognise that many people benefited from some income apportionment, the majority of those impacted were overcharged and in some instances had debt raised when they did not owe anything. Under this scheme, these people will be made to accept a relatively small amount of compensation, despite the debt having wide-reaching impact on their financial security and general well-being. The bill also includes provisions that will require people to sign away their right to hold the Commonwealth to account in exchange for inadequate compensation. Further, the bill seeks to validate income apportionment retrospectively, which denies people the chance to have their cases properly considered and potentially undermines confidence in the rule of law. Overall, Anglicare Australia welcomes the steps this bill takes to update the outdated debt waiver provisions and to deliver better outcomes for those in the debt system who experience family and domestic violence. However, the income apportionment resolution scheme as drafted fails to deliver a completely fair resolution. We call for the committee to strengthen the bill by ensuring people are properly compensated for their losses and by rejecting retrospective lawmaking and by restoring a statute of limitations on debts.
Thank you. Can I just get the witnesses in the room to just state their names for Hansard, please?
I'm terribly sorry, Senator. Casey Chambers, Executive Director, Anglicare Australia.
Thank you. And is it Ms Brown?
Bernie.
No? Barney?
Bernie, yep.
Bernie, sorry.
That's okay, no problem, Senator. My name is Catherine Burney. I'm the Executive Director of the Working with Women's Alliance, and I lead the National Women's Safety Portfolio. Thank you for the opportunity to address the committee today. I would also like to begin by paying my respect to the traditional owners of the land, the Ngunnawal and Ngambri people, on which we meet, and pay my respect to the elders past and present, and also extend that respect to First Nations people on the call. I'm grateful to be joined by my outstanding colleague, Therese Edwards, CEO of Single Mother Families Australia. The Working with Women Alliance represents over 900 members who lead Australia's response to gender-based violence and women's economic equality. We welcome the government's commitment to reforming social security debt framework and recognise this bill as an important step in the right directions. This bill represents a critical inflection point. The bill offers some technical clarity in the management of social security debts. Its real-world impact lies with women and children who have suffered domestic, family and sexual violence, especially those subjected to financial abuse and coercive control. These are not simply administrative amendments. They are reforms that touch the safety and dignity and economic futures for those who have already experienced significant systemic harm. Our submission recognises the positive intent behind clearer grounds for debt waivers and the acknowledgement of financial abuse and coercion for the first time. This recognition is major and a long overdue milestone, and one we strongly support. However, without careful amendment, the bill risks embedding historic injustices. Retrospective validation of income apportionment from 1991 to 2020 could leave thousands liable for repayments on debts that were a direct result of coercion or abuse. Imagine a woman forced by her abuser to hide and falsify information. Under this bill, she may still be liable for debts generated by that abuse with little recourse for redress. While a new resolution scheme exists, the compensation it provides, capped at $200 to $600, is non-individualised, modest, and may pressure survivors to waive broader legal rights. With some refinement, this scheme could become a meaningful pathway to redress, but as it stands, many survivors there is a risk that they are left with little real remedy. Survivors' experience must be at the heart of this reform. The barriers to accessing justice are steep. Many cannot provide formal evidence, such as police or court reports, and ongoing engagement with Services Australia can potentially re-traumatise those who have already faced overwhelming adversity. Recognising this, our key recommendations are expand automatic debt waivers so that any debt linked to documented financial abuse, coercion or duress from 1991 to 2020 is proactively identified and extinguished by Services Australia unless there is clear evidence of fraud. Adopt a tiered trauma-informed compensation regime, one that weighs on the serious and duration of harm and allows for independent advice before accepting any waivers and offers of additional reparations where warranted. Mandate trauma-informed, survivor-centred service delivery, requiring all relevant staff to be trained in domestic, family and sexual violence and the dynamics of coercive control and its trauma impacts, and establishing specialist liaison officers to support those navigating debt relief. Accept diverse forms of evidence, from survivor testimony to statutory declarations to patterns of financial transactions, rather than insisting on legal or police documentation. Resource community outreach and remove intersectional barriers, especially for First Nations, CULD, LGBTQ+, disability and regional cohorts through culturally appropriate and accessible formats. With these amendments, Parliament has the opportunity to turn an important bill into truly transformative reform, one that not only provides legal certainty but also delivers fairness, safety and restoration for those most harmed by both financial abuse and administrative failure. Thank you. I welcome the questions.
Thank you, Ms Burney. Ms Edwards, did you want to make a short statement as well?
Can you hear me? Oh, fantastic.
Yes,
Good morning. Thank you so much. I'm phoning in from Ghana Lands, and it's really important. I'm Therese Edwards, the CEO of Single Mother Families Australia. It's really important that I'm at this event, and I thank Kat for inviting me in to be part of the National Women's Safety Alliance. And why it's important is because this bill disproportionately has affected single mothers, mothers who are in receipt of the parenting payment single. And I agree with all of the comments made around the strengthening of the bill, so I won't echo that. But what I will also say is how important it is to wipe those debts. So having a social security debt, it leads to the no application of any crisis loans. Women cannot access annual supplements. Often tax returns are intercepted. And there is a really ferocious way of recuperating those debts. And for women with care, that can actually mean the holding back of their family tax benefit, which is the only public support available for raising children. We think this is a gigantic step forward. We really welcome the intent, not only practical, but also culturally. However, our submission also talks about an omission from this, the debt waiving opportunities, and this legislation does not include debt waiver for women who have experienced financial abuse through the child support system. So we have in our submission, we've laid out the consequences of not including that provision, also the remedies for that provision, and I'm really keen to answer and respond to questions. Thank you.
Thank you, Ms Edwards. I'm going to hand the call to the Deputy Chair, Senator Norman-Payne, for some questions.
Thanks very much, Chair, and thanks everyone both for your submissions and appearing before the committee today. I'm very interested, I guess, in unpacking, first of all, the periods for the debt waiver provisions. So the legislation that we have before us has identified that the debt waiver automatic provisions will be limited from 2003 to 2020. I'm interested to know from any of the witnesses, and this is open for anyone to answer, this legislation doesn't consider debts from income apportionment from 1991 to 2003, and I'm interested to know on your view on how this may impact people with debts from that period and whether you've in fact heard from or been dealing with people who have debts as far back as then. Might start with ACOS.
Yeah, thanks, Senator. Yes, you're right. The resolution scheme is restricted to income apportionment affected debts only from 2003. And of course, we know that income apportionment was used to assess people's fortnightly entitlements well before 2003. And so people affected prior to 2003 won't be able to access the resolution scheme. It's unclear to me why that somewhat arbitrary date was put in place. But of course, it's also unclear what would happen for someone who knows that they had a debt that was income apportioned and they're wanting to seek redress, because the government is going to also make income apportionment retrospectively lawful. So I think there's some very good questions that need to be answered by the government in terms of what someone in that position would be able to do. I note that the Ombudsman did suggest that people's right to make a claim under the defective administration program, for want of a better term, may not be affected by this bill, but I think that people at the very least need a lot more information about what avenues they may have to essentially be compensated and also collect money that they're owed from the government. Thanks.
Thank you. Do any of the other witnesses have a position on that particular question?
No, Senator, not really. But I would make a comment about some of the difficulties for people in working through debts and working through communications with Centrelink and Services Australia. We did some research some years ago now, but we looked at people coming to our emergency relief and housing and financial counselling services for those kind of services. And we looked at how much time it took us to work through some of their Centrelink issues. And at the time, we had 218 staff in that study, and we estimated the amount of time that it took them to work through people's issues with unclear letters, unclear communications, was actually 6.6 FTE of that time. So in a sample of 218 staff. And I use that simply as evidence that it can be very, very difficult. We've also heard case studies as we've worked through to appear today around how difficult it can be, and people representing and going with clients to Centrelink and getting one answer from one officer and 5 minutes later another answer from another, which all doesn't answer your question but all adds to some of the complexity of information that's there in the Social Security Act for both public servants to interpret but people to deal with, as they also deal with complex everyday lives that we all lead.
So, Ms Chambers, would it be your position then that it would be better if this legislation expanded the automatic waiver provisions as far back as 1991 so that we've got a larger cohort of people who are not having to engage with that complexity to try and recover money from debts?
Notwithstanding that we think $600 isn't enough compensation, we are not clear. We can't see any reason why it doesn't go back that far, other than perhaps the administrative burden on people trying to work that out. We looked at the parallels with the National Redress Scheme for institutional responses to child sexual abuse to see if there were any parallels there that we could understand. We would not see any harm in taking it back to 1991.
Great, thank you. I might go then to the next thing that you raise, Ms Chambers, and that you've all raised in your submissions, and that is the inadequacy of the upper limit of the compensation payments, noting that it's currently set at 200, 400 and 600. So I guess I'd like to get a sense from you all as to what you think those limits should be, and I guess whether there should be an upper limit, and if you have any examples of people, for example, who, if they took that $600 compensation payment, would actually be inadequately compensated. So whether you have any case studies of people who in fact are owed more.
We find that $600 is inadequate, but particularly when we look at those capped amounts, any of us with any experience working in the public service know that it would cost way more than $200 to assess whether somebody is due for $200 or not. So the mere fact that something is capped at $600, I think even if it was $600 for everybody, regardless, and that would be a fairer compensation. It would be a fairer use of the term compensation, that this was a goodwill gesture to put things behind everybody. And we do accept, I perhaps wasn't generous enough in my opening statement, we do accept that this is a very difficult situation. It is a very hard omelette to unscramble, and that the government is acting with generosity and intention to right these wrongs. However, 200 and 400, it's going to cost more than that to work that out. Certainly, we hear from people who have had, just in terms of appearing today, spoke to one person who had a debt of $1,190, another person with $1,600, another person with $12,000. Some of these debts were really quite large and found since to be not these ones, the person I talked about with 1,190 was found not to actually be owing that, in fact to owe nothing, and in fact in the end received a back payment of $85. So accepting 600 would have put them back at about $1,200, which again doesn't sound an awful lot to some people, but it really is. And the distress that it's caused has been immense.
Would anyone else like to speak to that particular question?
I think I'd probably, Senator, make a broad comment, this is Catherine Burney, that when we're talking about these historical debts from 1991, we need to take into consideration the length of time for a disclosure, for people recognising behaviours that they've been exposed to. And again, I think I agree with Ms Chambers that the stress and trauma and re-traumatisation that this engagement costs for system error, which is really, to be honest, unacceptable, particularly if it's something that's meant to be supporting people that have been coerced or living under financial abuse. And remember, from 1991, we didn't have the language for that. It didn't exist in social policy. So I think when we're thinking about people who are exposed to those behaviours, we need to have an understanding, a grace and an acceptance that they may have not had the language themselves to be able to identify their experiences.
Thank you. And I might just check, Ms Crowe, whether you would like to address that point.
Yeah, look, Senator, the government's own sampling exercise shows that while in that sample most people may be sufficiently compensated with this resolution scheme, actually there are people who are owed thousands of dollars. And that's just on the basis of that very small sample of 970 people. So I think that shows to you that this scheme is going to absolutely fall short. I also point to analysis done by Darren O'Donovan that showed because the majority of the income apportionment affected debts were reduced, and he showed that the average reduction was 36%. Now, if you take someone, say, with a $5,000 debt, and under this resolution scheme, the most that they would receive would be $600. Actually, if it was reduced by 36%, that's $1,800 that the debt would have gone down by. So you can quickly see how the scheme will fall short. Finally, the scheme obviously doesn't address, the stress of having that debt, having to pay however much it was, which is always a huge amount, irrespective of the amount of the debt when you're on a social security payment. Almost half the people affected by this scheme still receive social security, and so are by definition going to be on a low income. And it also doesn't factor in, loss of family tax benefit that may have happened if the person paid a 10% recovery fee, and other flow-on effects from having a debt, like not being able to access an advance payment, which may have seen that person not be able to pay the rent for that week. So there are a whole lot of flow-on effects that I think the resolution scheme for a lot of people fails to recognise.
Thank you. Thanks very much, Chair.
Thank you, Deputy Chair. I'm going to go to Senator Collins.
I think, hearing about this issue, it is very distressing to hear that people are being asked to pay back debts that they are not owed. I just want to understand, so that they're not legitimately having to pay back, and this has been going on for many, many years, particularly for women. I just want to understand, we've heard a lot about how this is a big issue for women who have experienced financial abuse, but it said at the start, like the submission, not your submissions, but the sort of explanatory position that 5.5 million in struggle debts may be potentially affected by income apportionment. And Ms Crowe, you said that 160,000 of those debts should be waived rather than recalculated. Why have you landed on that number? And how many of those do you think could actually be owed money from the government, like you suggested? And are these 160,000, the women that are affected by financial abuse? Just can you just sort of unpack it a little bit for me?
Yeah, thanks, Senator. So the 160,000 refers to income apportionment affected debts that are currently paused. So when the way that income is assessed under the Social Security Act changed in December 2020, after that the government realised that it had before then been unlawfully calculating people's entitlements, and those debts refer to debts that had not yet been paid or were in the process of being paid but hadn't been paid in full. When the government realised there was a problem, it paused recovery of those debts. And so we've argued in our submission, at the very least, for people some of whom have been waiting for years for this issue to be resolved, that they at least be waived.
Are you saying debts are illegitimately being asked to be repaid, or have all of them been assessed? So how many of those 160,000 could actually be legitimate debts to the government?
Well, that's a good question, because it depends on whether this legislation passes and income apportionment is retrospectively made lawful. Otherwise, the government would need to, recalculate those debts according to the law as it was prior to December 2020. They're good questions to be putting to the government. But our point is, because people have had to wait for so long for this matter to be resolved, because we had a federal court case, etc., that it would be fairer for those debts to be waived in full, recognising the distress that happens when people have a social security debt hanging over their heads and there's literally nothing that they could have done about it, because the government took quite some time to resolve this issue.
And what would be the total amount of those 160,000 debts?
I think that's in the ex-mem. I'd have to go and check that, Senator.
Okay.
But acknowledging that some may need to be recalculated, right? Yeah.
So some may be owed money, some may owe money, but that total number is not going to be the same. Well, it'll go in different directions, but effectively the total amount will be the same. Okay, thank you. Ms. Burney, you said that you wanted to expand the debt waivers back to 1991 unless there was clear evidence of fraud. What would the clear evidence of fraud look like?
I think that currently the fraud threshold of evidence is sufficient in terms of from a Services Australia and government perspective. But I think, so the evidence that's currently used to calculate that, those standards are sufficient and should be applied. But I think it goes back, Senator, to my previous comment that a lot of people didn't have the language for what was happening to them. You know, we didn't have an awareness that we have now to be able to see from an administrative point of view patterns of financial coercion and financial abuse that absolutely exist in 1991 to 2020. Let me be very clear. These behaviours have existed for decades. It's just we didn't know how to recognise them, identify them. We didn't have clear definitions. Those clear definitions exist now. Those clear patterns exist now. So it should be retroactively applied for people.
I absolutely agree. I'm just going to stop you there because my question is about the fraud element. So, fraud is a huge and absolutely exponentially growing at the moment. So what are the parameters? What are those standards that you're talking about? How do we identify the fraud, particularly all the way back to 1991?
I think when we're talking about coercive control and we're talking about financial abuse, which is in the specific context sort of our submission, I think we need to be really clear that people don't make false accusations. There is enough evidence to support that false accusations are incredibly rare. And I think what the calculation then needs to become is how much of a risk is a fraudulent claim. I think The problem is that we have set up our social security system with the concept of fraud forefront rather than support for people. And I think when we say there are clear indicators of fraud, okay, so if there were forged signatures, if there were claims put in under different names or non-matching signatures, I think those thresholds are sufficient to be looking at. But we also need to change the way...
That's all part of coercive control as well. What I'm saying is that, we're like... I'm not. I mean, I believe in what you guys are doing, and this is important work to
definitely.
do. But on the one hand, you're saying we don't need any evidence of this, and that's fine, and we shouldn't, because coercive control is really, really difficult, really, really difficult. But part of that coercive control is forged signatures and all the stuff that you were just mentioning there. And then on the other hand, you said you need absolute clear, parameters around identifying that fraud, and actually that fraud is only going to be a small element of that, and people don't lie. But we know that they do, and we know that the hugest part of cost in NDIS is the fraud element, and so. I just want to understand better from you. How are you going to delineate those two things?
Senator, I think that I don't disagree with you, but I think that is why we've also said in the conversations we're having with Minister Plibersek's office are very clear that we need to ensure that there are very clear evidence thresholds that have to be met. Now, we also don't believe that those evidence thresholds should necessarily align with the criminal standard. We have inconsistency in how coercive control is legislated in state and territories. We have a national set of standards and a national set of definitions. Now, what is the evidence threshold that is going to be required? At this stage, this bill, it is unclear who is going to be making those decisions. Now, we will have social workers that are part of that. We don't work from a fraud lens. So for me, I think unless there is clear fraud that doesn't fall under the national definitions and standards of coercive control and financial abuse as outlined by recent committees, I think what we need to do is then believe people. And the problem is that whilst I appreciate fraud is growing, we have a tendency to not recognise the experiences, particularly of women and children who have been living in violence, because it is easier to believe that it's a false accusation than the behaviours that people have been exposed to.
Thank you so much, Ms Burney. Ms Edwards, thank you so much for all of the work that you do for single mothers in Australia. I just wanted to also get a sense from you, how big is this problem of financial abuse for women? And particularly
That's the last question, Senator Collins. I'll have to rotate the call. Sure. I'll give it to Ms Edwards and then we'll pass on to Senator Brown.
Thank you. You're just on mute, Ms Edwards.
Okay, I'm hoping this is working now. Fantastic. Look, thank you very much. A couple of points. First of all, around the believing of women, we would like to start from that perspective, and we have a lot of there is a body of research. The third-party verification, for example, that highlighted that fraud was actually not part of the system. So if we started from the position of belief that we would not have traumatised women. Also, just 2 points that I did want to make. In preparation for today, I spoke to one woman. She's suffered financial abuse for 22 years, raising 2 autistic children, and the consequences of that is not only a reduced social security entitlements, but she also could not get banking products and was deemed inappropriate for any sort of loan. And then when I go back to the earlier conversation of going back to 1993, I was also talking to a woman who, because of her social security debt, was deemed as inappropriate, and her children were removed from her custody and granted across to her partner. So when we talk about having a social security debt, the ramifications are really deep and they're really long, and not having the language or women not even recognising it is part of it. So, so a quick couple of points to I hopefully answer your question, that it's important to go back in time. It's important to look at the consequences and the cost to match those consequences.
Thank you, Ms Edwards. Sorry, we have to move on to Senator Brown, who has some questions for you also. Senator Brown?
Thank you, Chair, and thank you all for providing your evidence today. I firstly just want to go to the issue of recalculating debt. And in one of the opening statements, I think it was from ACOS, talked about the immense amount of work that it would take to recalculate and how practical it was to recalculate the debt. And doesn't the system that's in this bill actually go a long way to taking the stress that we know when you've received a debt that isn't fair or actually hasn't been incurred? Isn't this system that is proposed to be put in place a good way to start?
Yes, thanks, Senator. Look, for a lot of people affected by unlawful calculation of people's payments, the resolution scheme as proposed will sufficiently compensate them for money that they're owed. And indeed, some people may receive a little bit more than what they're actually owed, but I really do think that just recognises that the government unlawfully administered the system for some time. Our concern is for the people that it doesn't actually sufficiently compensate. Just because some people will actually be okay or be better off doesn't make it right for the other people who will be absolutely undercompensated with this scheme to not receive the compensation that they deserve. And whilst I appreciate that it is difficult because a lot of the records and information that would be required to accurately calculate someone's social security entitlement may no longer exist, right? Because it has been happening for so long. I think for where it's very clear that someone is actually owed more money than what the scheme provides, then they should have an easy way to do that. I also want to note that a lot of people affected by this actually had a robo-debt. And, you know, they at the time provided their pay slips and did all of that work involved just to prove their innocence, only to have, you know, their entitlements income apportioned at that time. And so they managed to get around one unlawful part of Social Security administration only to be affected by another. So there's I guess this is just to say that we just think that there needs to be sufficient compensation for people who are owed more money. And if I may, I just want to go to a point that Senator Collins made earlier, that to indicate that fraud has increased in the social security system. That's absolutely untrue. We've seen, in fact, prosecutions go, or the fraud cases of actual fraud go down. And I'm happy to refer the committee to the latest annual reports from the the Commonwealth Director of Public Prosecutions.
Sorry,
thank you.
NDIS, not social services. Thank you.
Just wanted to be clear about that.
Yeah.
Thank you.
But you acknowledge here in all your submissions, I believe, that your support for the bill that you've got before you as a good first step and in many respects. When we talk about the protections in there about debt incurred because of coercion or financial abuse, they're all good first steps.
Absolutely.
I believe this is more than a first step. I think it sets a different culture, it sends a different message, and I think we've got an opportunity to not, I think that message may be harmed with a price tag of $600 on it. I know that that's not the only part of this bill, but that is part that a lot of people will see. But I think it's far more than a first step. I think it sets the first stage for righting a lot of wrongs and for righting culture.
And we are talking about over 800,000 people that will be have their debts waived. We're talking about a significant amount of people that have their debts resolved under this bill. And is that correct?
Yes, and we would totally support the increase to the small debt threshold. Those debts can sit around, as somebody else made the comment, for people for years and years. They have long-standing effects on people. They stop people getting any kind of start in lots of ways. And, you know, to be pragmatic, they're also very difficult for the Commonwealth to actually administer. So we think that increasing of the threshold is very much to be appreciated, approved and passed. And we would also, you know, say that if that could be indexed, that would be great. We know the cost of administrating it, and we know the cost of people trying to scrabble to get that bit of money back together again.
And I would like to also, if I may, Senator Brown, just really echo those points because for many, many years, in fact decades, people who rely upon our safety net, we've actually demonised them. And when there's cuts, it's usually to the social security. Where there's more work for people to do, it's in the social security system. So this is a cultural statement as well. This is why it is manufacturally an administrative outcome, but it's also a cultural statement, and this cannot be lost. So we're hoping that this will build on the fantastic work of saying to Australians, if you are in need of our social security net, you can do that with respect, without feeling that you are not being believed, and that you will be safe to do that. And we have before us opportunities like, for example, the evidence. We have a great system now for leaving domestic violence, where there is the standard of evidence to provide that you're being affected by gender-based violence and financial abuse. We could bring in a similar system in this one, which really centres the testimonial of victim survivors, but it could be as simple as getting a stacked deck, because one of the things that we did learn through the work that moved from the Escaping Domestic Violence to the permanent program was that 80% of people who sought out that program had not gone through a formal expert service. And so whilst there are those expert services, I would predict that the majority of people who will be receiving and in line and should be compensated perhaps won't even know of those services that are available, and they'll be navigating that system solo. So there's so many good things in this, and I think all of us just want those ceilings and the fairness to be expanded, but we cannot go past it. This is such a good cultural statement.
Thank you. Just one last...
Thank you. Senator Brown, this is the final question. I'm sorry, ladies. I know that we're all very passionate about this issue, and it's such a the inspiring work. I'll give Senator Brown the final question, and then we unfortunately need to move on.
Okay. Just back to ACOS, I notice that as part of this bill you receive a grant of $400,000 to facilitate the uptake of the resolution scheme. How important do you see the work of effective communication and support for people affected by these changes?
Oh, look, that's going to be critical that the government effectively communicate to the community that the scheme is available, and it's also going to be really important that people access legal advice in many instances to see what the best course of action will be for them, which requires adequate resourcing of community legal centres around the country supporting people receiving social security payments to get that advice. We note that they are currently underfunded to meet demand, and this will only add to the demand. And I do note that Economic Justice Australia, for instance, is also going to be receiving $400,000. More broadly, and this is also why we've recommended that the resolution scheme timeframe be expanded from 12 months, we know even with the robo-debt refunds that there are still robo-debts to be refunded, the highest of which is over $20,000. And we are now, over 5 years since robo-debt ceased. So that just demonstrates how difficult it is actually to communicate to everybody affected in the community that a refund or compensation is available. So it's going to be critical if this bill is passed and we have the resolution scheme that the government does everything it can to ensure the message gets out there.
Great, thank you. Thanks. Unfortunately, that's the conclusion of this session. Can I thank you all again for your evidence today? The committee will report to the Senate on Tuesday, the 21st of October, 2025, and it has agreed that the responses to questions on notice should be provided if you've taken any today at the close of business on Thursday, the 9th of October. So thank you all again for your work and your evidence today. We now move on to representatives who I'm welcoming from the Economic Justice Australia, Financial Counselling Australia, and Mobstrong Debt Help from Financial Rights Legal Centre. Thank you for appearing before the committee today, and I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, please state your full names and the capacity in which you appear today.
I'll jump in first. So my name is Veronica Williams. I'm from Economic Justice Australia. I'm senior lawyer there.
Thank you. You're on mute.
Happy to jump in. My name is Rebecca Sarkozy. I'm the Director of Policy and Campaigns at Financial Counselling Australia.
Can you hear me now?
Yes.
Okay. My name is Bettina Cooper. I'm a Bowen Dick woman, and I'm a Mobstrong Debt Help Senior Financial Counselling and Strategy Lead, which is the Program of Financial Rights.
Deb Shroot, Financial Counsellor at Financial Counselling Australia and also Sector Advocate.
Great, thank you. I'm now going to invite each of you, if you have one available, to make a short opening statement of no more than 5 minutes. At the conclusion of your remarks, I'll then invite the committee members to ask some questions. So I think we'll go to Economic Justice Australia first.
Thanks, Chair. So I would just like to quickly acknowledge that I'm on Bunurong country, and I'd also like to thank the committee for the opportunity to participate remotely, and my 5-month-old also passes along his thanks for that. It's greatly appreciated. A little bit about EJA. I think it's important to note that we are the peak body for community legal centres who provide specialist social security legal advice. So that's people that help customers with Centrelink issues directly in a legal sense, whether that be helping with authorised review officer appeals, going to the tribunal, or helping in other ways. The comments I'd like to make during this opening statement are just briefly about each of the schedules in the bill, and I'll try and keep this brief because we can go into it more in questions, of course. So with Schedule 1, dealing with income apportionment itself, our view is that this is mostly good. We don't have a problem with this passing as such. We would like to note, though, and make sure that the committee is aware that the test case, the Chaplin matter that went to the federal court, we are aware that special leave has been sought at the High Court to actually have that reviewed further. while it's hard to predict what was going to happen with that or whether they would actually make a different decision, our view on this bill may change if there was a different decision at the High Court. So I think it's hard to say what to do with that, but it's worth bearing in mind that that could happen. In terms of Schedule 2, the changes to the debt waiver provisions, we overall think that these are good as well, as in if they were to pass into law, we'd be mostly happy with them, though we do have some concerns about the special circumstances waiver in particular. The main concern that we have is the phrase justified in the circumstances. Every time we have discussed this with our member centre lawyers, they've balked at it. They've said that doesn't feel right. That feels like it's creating an extra barrier for people, particularly people who have experienced family violence, to justify what they did during times of stress, during times of duress and coercion, where they may not have been acting quite rationally. And when we're looking back on these situations, they may not be able to justify to the standard of an authorised review officer, for example, who I should also mention are not usually legally trained. So they may not look at this in the same way that we would as lawyers or legislators or other people who are professionals working in this space. Our view is that it would actually be more elegant and more fair to just get rid of paragraph A from the special circumstances waiver provisions altogether. And what that would mean is that the special circumstances waiver is just about whether there are special circumstances. The immediate objection to that will be, well, that will allow people to have debts waived in circumstances of fraud. I don't believe that is the case because a decision maker looking at this would have to factor in fraud as part of the overall circumstances. And I think it is very unlikely that a rational decision maker will say, yeah, you've ripped Centrelink off, you've completely defrauded the system, but I'm going to waive the debt anyway. So I don't think that's actually a real risk. In terms of what's missing from Schedule 2, the main thing would be a reintroduction of the 6-year limitation period, which was recommendation 18.2 from the Robo-Debt Royal Commission, which was given more than 2 years ago. We see this as the perfect vehicle to actually reintroduce that, at least as what it was before, prior to 2016, if not a better version. A version that we have advocated for in the past, though we are open to other versions, is a version that gives a hard 6 years from when the overpayment occurs for the debt to be at the very least identified and communicated to the person. In terms of Schedule 3, we also think that this is mostly good. We wouldn't object to it passing into law. The main concern that we have is that it should be very, very clear in the legislation itself that a person's merit review rights will not be impacted by accepting compensation. We would also note that giving up other legal avenues, other causes of action that a person may have by accepting compensation is a significant choice, and people are likely going to need legal advice before they make that choice. Thank you so much.
Thank you very much for that. I think we'll go to Financial Counselling Australia.
Thank you, Chair and members of the committee. Financial Counselling Australia is the national peak body for financial counsellors, representing over 1,300 financial counsellors and financial capability workers across 450 agencies across the entire country. Financial counsellors are independent, free, qualified professionals who sit alongside and support people in financial difficulty. A significant number of these clients are victim survivors of financial abuse. We see firsthand how government systems, including Centrelink, can be weaponised by perpetrators of financial abuse to create fraudulent debts, and how poor responses to those debts worsen hardship and entrench crisis. We welcome Schedule 2 of the draft bill, which addresses social security debt waivers. These reforms are critical. Fraudulent and coerced Centrelink debts trap victim survivors in cycles of debt and fear, making it harder to leave unsafe situations or meet basic needs like their food and electricity. The proposed changes will finally create a pathway for more of these debts to be waived, a change that is life-saving and changing. We strongly support the intent of these reforms, but the detail is crucial. The special circumstances waiver allowed debts to be waived in special circumstances or omissions only if they're considered justified by a Service Australia decision maker. This is highly subjective and risky. decision makers are not always qualified to assess family violence circumstances adequately. For example, one financial counselling client was told that unless they had a family violence order, they were ineligible for support, demonstrating a lack of expertise in what constitutes family violence and how this should be responded to. Without clear guidance and expectations, assessments of what justified could become yet another hurdle for these victim survivors which are seeking relief. The legislation explanatory memorandum or Social Security Guide should make it clear that the special circumstances waivers must be applied compassionately and also with trauma-informed approach. These are essential reforms, but there are also huge practical barriers that remain for people accessing these waivers, many of whom are navigating this extremely complex system in the hardest moments of their lives. Unlike community lawyers, financial counsellors have no dedicated point of contact at Services Australia to advocate on behalf of these clients. We must navigate complex consent processes, long waits, and repeated delays. Too many people are falling through the cracks because trusted financial counsellors like myself cannot advocate effectively on their behalf. If this bill is to be truly effective, this issue must be addressed. It is a huge barrier to help. Finally, while this bill is about the federal government delivering on its promise to prevent systems being weaponised for financial abuse, there is a persistent and serious gap. The ATO has no effective way to waive coerced tax debts, and the Finance Minister's debt waiver process is inaccessible, slow, confusing. Victim survivors are exposed to the same harms in the tax systems that this bill is seeking to fix. We urge the government to move quickly to also address this gap. Thank you very much.
Thank you very much, Ms Shroot. I'm going to go to Ms Cooper for her opening statement. Thank you.
Thank you, Senator Cox. Milestone to Help is a free nationwide legal advice and financial counselling service for Aboriginal and Torres Strait Islander people only. We provide information about money problems, debts, insurance, super. Mobstrong is a leading voice for First Nations financial justice through our strong advocacy around things like Centre Pay, Say Sorry Business Campaign and others. We've been able to work with regulators, government and financial institutions and being able to advocate for a more equitable and culturally safe space in line with Priority Reform 3. We speak to thousands of First Nations consumers each year across Australia, and they're all struggling with financial stress. Many of our clients are receiving Centrelink payments, and many are struggling with unmanageable debts. Mobstrong's position is we support Economic Justice Australia's position as laid out in their submission. We've worked closely with them on Centre Pay reforms and feel comfortable with the position they've taken. I want to speak specifically about the First Nations impact in relation to this bill. First Nations populations are disproportionate users of Centrelink, as evidenced by Services Australia's annual report and our work on Centre Pay reforms. Historical Centrelink debts create a burden of hunting down old pay slips and bank statements, which is time-consuming and stressful. Cultural, language, digital and geographic barriers on top of navigating an unclear system has resulted in an unequitable outcome for many First Nations people. We know many First Nations people in very remote and even some regional areas are employed in seasonal, casual or part-time work. That results in the fluctuating income that is most likely to cause somebody to stumble in the complex Centrelink digital maze of reporting your income to get your payments. And that means they're most likely impacted by the historical debts we're talking about today. The current draft of this bill does not include the reintroduction of the limitation period of debt recovery. This bill is the vehicle to holistically address Social Security debt reforms. And we ask that you action the recommendations from 18.2 of the Royal Commission into the Robo Debt Scheme and bring back debt limitation periods, please. The length of the limitation period could be shorter. Consider even 3 years. Think about how long 3 years really is to notify a person of a debt, giving a recipient a person certainty that but can't be longer than 6 years. 3 years is hard enough to go back and find your paperwork. 6 years is impossible. If it does not go in the bill this time, this debt limitation period, we are really concerned it won't make it this recommendation. We welcome a special circumstance waiver in this bill. However, we are concerned about the wording justified. First Nations people will have an additional hurdle if those who decide justified circumstances don't possess the cultural knowledge to equitably assess and understand the burden of evidence being requested. There is a risk of re-traumatisation with people, needing them to tell and retell their story of justified circumstances to meet the threshold of a debt being waived, and we ask you consider removing this. Bob Strong strongly agrees, as currently drafted in the bill, in increasing the small debt waiver from $50 to $250. Thank you for your time.
Thank you, Ms Cooper. I'm going to go to the Deputy Chair to commence questions.
Thanks very much, Chair. I might leave any questions around removing the words justified and taking out that aspect of the bill, because I think you've all spoken with one voice on that. I'm interested in unpacking a couple of things that we heard from the previous panel, and then how that sits with your view, and particularly in relation to Economic Justice Australia. So we heard from the previous panel that all of the witnesses have considerable concerns around the retrospective legalisation or validation of income apportionment debts. And in particular, there were concerns about the lack of waivers for people in that period prior to 2003, so the 1991 to 2003 cohort. And then there were also concerns around the fact that there will be many people who have debts that are significantly higher than the $600 upper limit in the compensation scheme, and for whom would be actually left significantly out of pocket. So I'm particularly interested, first of all, in finding out from you what are the impacts of retrospectively legalising the use of income apportionment going to be, particularly in terms of the rights and justice for those impacted, and whether or not you would actually support removing the ability of the government to make it retrospectively lawful. And I might start with Economic Justice Australia.
Thank you, Senator. I think our view is that it is a valid way of resolving the issue, because for most people, it's going to validate what actually happened to them. And so for most people, they can actually look at it and say, well, I haven't had a debt raised. I don't need to worry about this anymore. That said, it's not what we've advocated for in the past. Our position has always been that the most fair way of approaching this would be to waive all potentially impacted debts as a class of debt. And we still think that that would be a much fairer and much more adequate way of resolving this. Given that that's not what's on the table at the moment in this bill, we have to basically address what, still be happy with what we've got at the moment. I think that's the main thing that we would say. But sorry, the audio was cutting in and out a bit. Was there a second part to the question, Senator?
Well, I guess my question is, so obviously your preferred approach is to have an automatic waiver for that class of debts that are impacted by income apportionment. What the government is putting on the table is to make them retrospectively lawful. I guess I'd like to understand then, what are the legal ramifications for people who have had debts incorrectly raised due to income apportionment, and who may in fact be significantly out of pocket if the government is retrospectively making that lawful? What is the practical implication of that on people with debts?
Sure. I think it's really hard to say, and I think it's really unclear with the information that is available. Our understanding from what DSS have put out publicly is that most people will not actually have a significant change to their debts. Some people might, but in the vast majority of cases, it's going to be only a small amount. So I don't think it's been a significant concern raised by our member centres. That said, I did have the benefit of hearing the tail end of the previous people, and I do note that many people would, I think it was ACOS that raised this, many people would have actually had a robo-debt before they had an income apportionment debt. And I do think that's a really valid and important point, because whilst I'm looking at it with a legal lens, and whilst I'm saying, well, yes, making it retrospectively lawful does resolve the issue, it's not what we asked for, but it does fix it. And whilst I also think that there's nothing inherently unfair about income apportionment other than the fact that we're looking so far back retrospectively and trying to get people to get evidence from a time they don't have it anymore, the actual methodology itself is probably arbitrary or neutral. The stress that people have, having had a robo-debt and been through that process, and now having been through the income apportionment process, I think is significant. And that's really the main reason that we would push for a waiver rather than drawing a line under it in this way.
I note that Chris Rudge, in his paper, has talked about the fact that whilst the Ombudsman has characterised income apportionment as something, where the department, it wasn't, I think the phrase they use is, they didn't knowingly, intentionally do it incorrectly. However, Chris Rudge posits that this was a deliberate strategy of the department to use income earned when they had the ability to use either income earned or income paid. And they had a policy document that said the preference was to use income earned because they thought that it was a better way of stopping fraud. So in those circumstances, is this not a situation again where if the government chooses this path of making this retrospectively lawful, that some of the most vulnerable people in our community are again the people who are losing out when we see these repeated failures and unlawful actions by the department? And would it not be fairer, as you say, to simply waive those debts for that class of people and not try to retrospectively justify things that are in fact unlawful and have caused harm to people?
I will have to have a closer look at Chris Rudge's report on this because I haven't had the benefit of those comments. But yeah, I do think that a waiver would be the most fair way of resolving this.
Okay. One of the other things that we heard from the previous panel was that they felt particularly the $204 compensation payments were actually inadequate, and that they felt that the level of compensation should be higher, particularly given, the stress that people feel when they're having to deal with those debts. Do any of the panellists have a view on that? Might go to you, Ms. Cooper, first.
I don't have a view on exactly $204, but being the work I've done on Senate pay reforms over the last 2 years of my life, it's quite clear that they have learnt some lessons in that area for Services Australia from the robo-debt. Like, they did great embedding and co-designing and understanding of making sure people know their rights and that, but it took a hell of a lot of advocacy to get to the point for them to sit up and listen, a hell of a lot of media and a hell of a lot of pain that people suffered. In doing that, the harm was obvious. It seems to me that the robo-debt lessons need to be learned here, and $204 is nothing. It's not even a grocery shop these days. And if we've caused significant harm to the point that we've led to 2,000 people under robo-debt committing suicide or taking their lives, then we don't want to. We need to acknowledge the harm we cause with things where we've got things wrong in the past. And the government, part of the robo-debt reforms, we're basically saying owning their mistakes and acting on their failures. I don't know that $204 does that.
Thank you. I might also go to the debt waiver proposal to increase that from $50 and $200 to merge it into a $250 amount. And I know that a number of submitters to this inquiry have said that if we were to go back to the original amount, that debts would automatically be waived and it had been indexed, we'd be closer to $440. I might go to Financial Counselling Australia and ask whether you have a view on whether $250 is actually high enough, or whether it should be getting closer to the $440, $500 that other folks have submitted might be more appropriate.
Yeah, I'm happy to jump in there, and then Deb, you jump in too. Look, we don't have a specific view on the appropriate amount. I mean, coming back to the principle, better practice principles of compensation, making people whole is important. I suppose the concern is that we need to get this done quickly. People have been waiting a really, really long time.
Sorry, Ms. Sarkozy, I'm not sure if you understood the question. I'm not actually talking about the compensation payments. I'm talking about the amount, the floor at which all debts going forward are considered waived.
Apologies.
And is to make it $250, and a lot of people are saying if we were to keep up with inflation, it's to $440. So I wondered if you had a view on that.
Thank you for that clarification. So I think 440 is certainly the ideal, optimal amount, linking it. But as I said, I think the initial comment still stands that people have been waiting a really long time, and we want to push this through as soon as possible. And on the whole, the proposed reforms are a really good first step. So I'll probably leave my comments at that. Thank you.
Thank you. I might leave it at that, Chair. Unless there's time at the end, and can always circle back.
Yeah, thanks, Deputy Chair. I'll go to Senator Ananda Raja.
Thank you, Chair, and thank you all of you for your testimony. My question is directed to all of you, but particularly to Economic Justice Australia. It really relates to communicating of this issue and the remediation process. And I know Economic Justice, you've been awarded $400,000 as part of a grant to try and to communicate the complexity, but I think it will apply to all of you. We're all stakeholders in this. I'm just concerned that there is a narrative emerging that this is another robo debt, but I want to be clear that this is a historical debt process that at the time was not was actually designed to assist people, so that it was in the era of paper payslips, where we didn't have electronic processing of pay claims, and it was designed by the department to actually make it easier for recipients, so they didn't have to turn up with pay slips. Now been found to be unlawful, and we as a government ever used this system. It ended in 2020, but we as a government are now obligated to respond to that ruling, and that is what we're doing with this bill. And what we're trying to do, just to be clear, is strike a balance between this being both fair as well as fiscally responsible. So my question to all of you, but particularly to XCJ, is how do you communicate the complexity to a very vulnerable group of Australians, some of whom have the overlap and the legacy and trauma of robo-debt, but to make it clear that this is not robo-debt?
Thanks, Senator. I think the short answer to your question is with great difficulty and with great care. It is a very complex thing to explain. And even when explaining how income apportionment works, why it was unlawful and why it was, what actually happened, it's very difficult to explain to professionals working in this space in a way that makes sense, let alone to people who are stressed out of their mind with a Centrelink debt. So I think with great care is the answer, and I think that our member centres do a great job of communicating that to the clients they see. They have very limited capacity, though. They only see a small subset of people that actually have a Centrelink debt. So I think there is going to have to be a significant piece of work by the government. And I appreciate that, yes, EJA has been awarded some money, and that's a work in progress that I probably can't say too much about. I'm not even privy to the conversations around that, to be perfectly honest. But I think there is going to be a big piece of work by government to communicate and to these people, to reach these people, and to explain that, they might be entitled to some money, they might have some options with their debt, or there might be some other things that impact them.
Can you just take it on notice to perhaps present to us at a later point the comms plan that ECJ plans to use? Because it may be of use to other stakeholder groups such as yourselves?
Yeah, I can take that on notice.
Thank you. Would anyone else like to? I mean, it is a complex issue. I'm just concerned that we need to communicate this sensitively and truthfully as well.
Sorry, I'd like to make a comment if that's okay. So there is so much trauma from robo-debt. It ruined people's lives. And so financial counsellors, as an example, are there to help support people understand what's going to happen, understand, you know, what all of this means. We cannot do this if we are unable to get the answers ourselves. And currently, we do not have access to adequate support and access at Services Australia for financial counselling professionals to actually have the answers to this. We are in the queue with the general public, and often we cannot even get authority. If this is not addressed, we cannot support our clients. So it doesn't matter what reforms are put through, we can only communicate the knowledge we have, and at the moment we're even unable to get that knowledge.
So we will be hearing from the department later on. What question would you like us to put to the department with regards to that concern?
So the first thing is, ideally we would like some sort of financial counselling advocacy line, and be able to talk to a team who know what financial counsellors do, who are able to give financial counsellors third-party authority, implied consent, and also for us to not be waiting like up to an hour on the phone to get through, only to be told that we can't get third-party authority for our client. So we're talking about really basic access and access to a team that's able to deal with complex issues, because the current process flow is made for the masses, which is perfectly understandable. You need to be efficient. However, those process flows don't go across the broad spectrum that financial counsellors require, and it just makes it impossible for us to work with Services Australia. I can't emphasise this enough.
Thank you. I think that's good feedback. My next question, it's open to anyone on the panel. A few of you have mentioned...
I'd like to make a comment on that last question. Is that all right, Senator?
Yes.
Is that okay?
I'm running out of time. Yeah. Go ahead.
Oh, sorry. I will say that we've worked with Services Australia over the last 2 years with the Senate pay reforms, and I have seen them use the embedded co-design process, and part of that with communications has been the ability for First Nations leaders like myself to work through what is appropriate comms and test that plain English. I would encourage this process, if it goes forward, to have a similar model. And there is a blueprint model that now Services Australia has created for this sort of communications. Having that going inside the House with advocates and talking to advocates who are multicultural or disability or First Nations has helped break down that communication problem.
So this is the blueprint for Centre Pay, and you're suggesting that they use that as a template?
It's actually a blueprint for working with advocates that has been created out of the Senate pay reforms and is now publicly available and is acknowledged within Services Australia and acknowledged within government departments. In fact, the IGTO, the Ombudsman for Tax Ombudsman, and that have referred to it as well. So I would encourage you to maybe make that part of this process.
I like that. That's great feedback. My next question relates, and a few of you have mentioned this, the misappropriation of the social security system to perpetrate violence against women. Now, this is a huge priority for our government. Keeping women safe, the economic empowerment of women is a huge priority. And we understand that this stuff is baked into systems, and we're now trying to unpick it. There is some provision in this bill for a special circumstances waiver, along with obviously the debt waiver, which we've spoken about extensively. Can you just talk us through what impact that special circumstances waiver will have on your clients?
Yeah, I'll jump in on that one. Thanks, Senator. The
benefits associated with it and how it's different to business as usual.
Sure. The special circumstances waiver is a waiver that exists currently, and it allows for a debt to be waived where there are special circumstances that make that desirable. The current version of the waiver has a caveat to it, and it is basically that a person cannot access this waiver if they or another person has knowingly made a false representation or failed to comply with the law. So generally, if they've lied to Centrelink or given false information, or they've done something else wrong knowingly, they're not able to access the waiver. And the real problem with that is that, first of all, it's a direct vector for family violence. Another person, a perpetrator of family violence, can go and lie directly to Centrelink, knowing that this person, usually a woman, will not be able to access that waiver. The changes in this bill do go a long way to actually fixing that. They provide a mechanism for someone who has experienced family violence and has acted maybe against their own interests in terms of social security law at least, to access that waiver if what they did or the false representation they made was justified in the circumstances. It also provides mechanisms for where another person has made a false statement to also access that waiver if they didn't know about it, or if they did know about it, but the fact they didn't do anything about it was justified. For example, if there was a threat of violence, if you go to Centrelink and try and fix this, that kind of thing. As we said, I think all three of us said in our opening statement, the issue we have is that the phrasing of this provision it seems to be creating another barrier or another test that people will need to meet. So overall, we're very, I guess, happy with the reform and the direction that this is taking. And I will say for our member centres in particular, I think if the current version goes in, our member centres have very talented lawyers who will be able to use that to get debts waived for their clients where it's justified, and that's great. But for all the people who don't have access to that kind of support, I'm worried that they won't be able to meet that criteria and they will still have barriers in place.
Would the other panelists like to make a comment around that? The impact of introducing this change in this legislation, what it will have on the community of clients who are dealing with.
I would like to say that we agree with Economic Justice Australia that we're taking a legal lead from them. But on the cultural side is the justified issue when you look at different cultural family structures in First Nations communities and understanding the abuse that does happen from time to time, that there is that burden of trying to make sure that person can explain it in a cultural way that the person may not have that same level of cultural understanding. And unless Services Australia was able to make sure there was a culturally trained or a First Nations person for every one of those debts, there is a real risk that it may miss the mark. And it's also that risk of keeping the evidence and re-traumatising. So we like the amendment, but there is this worry that goes with it.
So culturally safe training as well as trauma-informed training would be important.
Yeah, it would be an essential.
Yeah. Okay.
Last question, Senator.
Oh, last question. Okay. I'm under the pump. My question relates to: did any of you raise this with the previous government? This issue?
So, I mean, not me personally, but certainly financial counsellors have been. Yeah, certainly financial counsellors have been aware of the issue and speaking out about it for a long, long time, which I think is where a kind of enthusiasm for passing these through with effective implementation comes from.
And Rebecca, what was the response from the previous coalition government?
Yeah, look, it's difficult for me to say. It's very much before my time. I think the fact that we're here now, having this conversation now, indicates that we certainly didn't get the outcome we were hoping to see.
Understood. And do you think that the amendments being discussed will restore some faith in the social security system?
I think certainly. I think if done well with the kind of additions that we've been talking about, to answer your earlier question around the impact, I mean, at a very high level, this particular circumstances waiver change will provide broader access to people to free themselves from debts that were not theirs, that should have never been theirs, that emerged out of some of the most unthinkable, cruel circumstances. So if done well in a trauma-informed way, certainly.
Yeah, and again, I stress that it was done unintentionally. It was not intended to be malicious. There was actually intent in the department over many decades to try and make it easier for Australians. It just all backfired, as technology evolved. But thank you all for your testimony and for the work you do. Thank you.
Thank you. And that concludes this session. And thank you all for your evidence. And just to echo Senator Nandaraj's comments just then, we thank you dearly for your work that you do alongside all Australians, and particularly those accessing social security safety net. If you've taken any questions on notice today, the committee will be reporting to the Senate on Tuesday, the 21st of October 2025, and has agreed that responses to any questions on notice should be provided by the close of business on Thursday, the 9th of October. The committee will now suspend for a break and recommence at 10:45 a.m. Thank you. Anti-Poverty Centre and the Darwin Community Legal Service. I thank you for appearing before the committee today, and I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, could you please state your full names and the capacity in which you appear today?
Yep, my name is Christian O'Connell and I'm a co-coordinator at the Anti-Poverty Centre.
And I'm Solomon Bahani and I'm a community solicitor at the Darwin Community Legal Service.
That's great, thank you. I now invite you to make a short opening statement of no more than 5 minutes, and at the conclusion of any remarks, I'll invite members of the committee to ask questions.
Sure, I'll just jump in. And I just want to note that for the purpose of the extremely short time available for this hearing, I'll speak on behalf of the Anti-Poverty Centre today. My colleague Jay Coonan is here though. And I want to acknowledge that I'm joining today from Gadigal country, and to reiterate what was said earlier in this hearing, that 9% of these debts are held by Aboriginal and Torres Strait Islander people, and the disproportionate harms to First Nations people are rife across the welfare system in every aspect of it as a result of the punitive rules imposed and that perpetuate extreme colonial violence. We have a great deal of difficulty seeing how we can support this bill when it's going to codify a substandard response, and it inhibits access to justice for people affected by income apportionment and unlawful income apportionment debts. Once again, we're being presented with a bill that wraps up a tiny number of positive measures with harmful ones, and putting advocates in an impossible position where to oppose the bill means that we have to oppose, the meagre improvements that it contains. It really is going to further undermine public confidence that the government understands its responsibility towards welfare recipients when, we see that this has been rushed as the only organisation involved in this type of work that is led by welfare recipients, where we are all welfare recipients doing our policy work. That we have had no involvement until today in this process. It is extremely telling that there is not a single submission from an individual person speaking about how this bill will affect them. And that is a result of the government's, extremely quick response to potential legal threats while we've been waiting 2 years now for real action on robo-debt royal commissions, recommendations such as the 6-year debt recovery limit that has been noted by everyone as absent from this bill. So, we have illogical provisions contained in this bill. It, for example, has that start date of 2003, which seems to be based more on convenience for government and bureaucrats than any other purpose. It is not the fault of welfare recipients that the government is in a difficult or complicated situation. I mean, obviously, governments over many decades have overseen this just failure to bother administering social security law correctly. I also want to quote Chris Rudge, who said that retrospective laws intrinsically represent an encroachment on the rights and freedoms of the citizens they affect. And so we're just kind of wondering whether the government is planning to make a habit of retrospectively making its unlawful decisions legal for everyone, or is this just something that's going to continue targeting the poorest people in society, because it isn't the first time this has happened. We are working with people who engage in good faith in the social security system, receive payments that they should be entitled to, and they are entitled to. And as a result of compulsory, activities like mutual obligations, receive debts that make no sense and that shouldn't exist and are completely cannot be wiped under the current debt raising and recovery regime. We're working with people who have been criminalised through unlawfully calculated income apportionment debts, who now cannot get back into the workforce because of the effect that criminal record is having on their ability to find employment. Obviously, that is a horrifically perverse outcome from the way that people are being punished simply for seeking access to support. The proposals in this bill are not fair. They provide less recompense to the people who experience the greatest harm and impose more burden and risk on those people if they do want to try and get a more meaningful amount repaid to them. We see a justification that this is all happening in good faith, that the department was operating in good faith. But there is a clear pattern of bureaucrats failing to uphold the law, and there's no excuse for that. We don't accept at face value that they didn't understand what they were doing, and all of this, again, is the product of the toxic culture and attitudes towards welfare recipients that Commissioner Holmes urged the government to abandon. Obviously, we have made our recommendations in our submission, but to highlight a few, these payments should be made automatically to everyone who the government has identified as being affected, with no burden on the person or on Services Australia, and that should not limit anyone's ability to access further compensation. We would like to go more into that during the question time about why that is so important. Obviously, remove the time limit on the resolution scheme. It's absurd that people are expected to act on this within 12 months. Remove all the provisions barring people from accessing support. Obviously fund the community legal centres so they can help people navigate this, and bringing back that 6-year time limit, as well as ensuring that people who have been underpaid can access, to be back paid for things that they should have received and didn't from Centrelink. And finally, we'll say it's obvious that this small increase to the small debt waiver limit is inadequate, and that should go to at least $500. There is a lot more needed to change the way the culture and practice of debt raising works. But ultimately, the obsession with targeting has to be abandoned. The government has to stop avoiding accountability, and the social security system needs to be returned to its beneficial purpose.
Thank you, Ms O'Connell. I'll go to Mr Bahani.
Thank you, Chair. I'm joining you today from the Larrakia country. Firstly, we welcome the opportunity to appear before the Senate committee today. We are optimistic about the positive steps being considered in Schedule 2 of the bill. First, we welcome the amendments to broaden the Secretary's power to waive debts when there are special circumstances making it desirable to do so. We are supportive of the intention for this amendment to operate retrospectively, because a person, especially a victim survivor of domestic and family violence, should not be deprived of relief on the sole basis that their debt was raised before a commencement date. Second, we believe this bill provides an opportunity to create consistency between the relevant statutes in relation to waivers for administrative error. By way of background, a person who has a social security debt raised against them generally has 3 options to challenge the debt. The first option is to demonstrate that the debt was incorrect in some way, whether that be a miscalculation by Services Australia, or maybe that it was raised based on incomplete information, whereby the recipient can complete the picture by providing that additional information. Second, they could seek a waiver of Services Australia's right to recover the debt because special circumstances other than financial hardship alone make it desirable to do so. I just note that in relation to circumstances, if they are established, such a waiver is discretionary in nature. The final option is generally to seek a waiver of Services Australia's right to recover the proportion of the debt that is attributable solely to an administrative error made by the Commonwealth. Unlike the special circumstances waiver, an administrative error waiver is mandatory. Across all relevant statutes that are being amended by the bill, administrative error waivers at a basic level apply to the proportion of a debt that is attributable solely to an administrative error made by the Commonwealth, where the debtor received the payment or payments that gave rise to that proportion of the debt in good faith. The administrative error waiver is currently enacted in Section 97 of a new tax system, Family Assistance Administration Act 1999, and Section 195 of the Paid Parental Leave Act 2010 includes an additional requirement that the debtor would suffer severe financial hardship if the debt were not waived. The former Administrative Appeals Tribunal, Henry Stubbs and Secretary Department of Family and Community Services, 2003, case reference AATA, starting at page 729, observed that, and quote, severe financial hardship, while not implying destitution, goes beyond straitened financial circumstances and imports a need for the particular case of a person to include financial suffering of severe or extreme nature. It is our view the application of this additional criterion to a debtor is arbitrary and can potentially lead to unjust outcomes whereby debts occurring by no fault of the debtor cannot be waived. Social security debts can place significant financial strain on a debtor, and where the debt was solely the result of an administrative error by the Commonwealth, we believe this may lead to absurd situations whereby relief is denied because, and I do hate to phrase it this way, the result of the administrative error did not cause enough detriment to the debtor. That concludes my opening statement. Thank you.
Thank you, Mr. Bahani. I will go to the Deputy Chair for a call on questions.
Thanks, Mr. Bahani, and thanks, Ms. O'Connell. I note that when we questioned Economic Justice Australia in the previous panel, and I put to them what was their opinion on people's legal rights being restricted by retrospectively making income apportionment legal, their response was that their preference would have been for an automatic waiver of the class of debts impacted by income apportionment, but it was only making it retrospectively legal that was on the table. I also note that the government has characterised this bill as being fair as well as fiscally responsible. Noting your opening remarks, Ms. O'Connell, around the need to remove the time limit on the resolution scheme as well as removing provisions restricting people from seeking meaningful compensation, I'm just wondering if you'd like to elaborate a bit more on why it is that the Anti-Poverty Centre and the people they represent are very concerned about this it being made retrospectively legal, and why you think that needs to change.
Yeah, this is only fair from the perspective of people who aren't affected by it. In our submission, we've made clear we also support a full debt waiver. I mentioned someone in my opening statement who's been criminalised and he has been incarcerated as a result of one of these debts. There is no amount of money that can make up for the harm done to that person. But under this scheme, not only may his debt be recalculated, if he is deemed, to be able to get that compensation, it will be $600, and his debt is in the tens of thousands of dollars. It is not clear how much he would be entitled to if that debt was recalculated, and the risk for him of seeking to have it recalculated is that the debt may be higher, and he doesn't know. He is living with this uncertainty, and he's been living with the consequences of criminalisation now since 2018. So I don't think it is fair to say that people in his situation should receive such a meagre payment when, rightly, people who had a debt of, say, $110 will receive $110, although I note that that has not been indexed and that value of that $110 may be different today than what it was when that debt was raised. It is not fair, obviously, to exclude people back to 1991 because what is the difference? I'm not sure if I'm affected by this scheme because I got a small debt like this and I can't remember if it's in like 2002 or 2004. How much time am I going to spend on the phone to Services Australia trying to find that out? I'm not going to actually go into every reason. I just realised I could spend 10 minutes talking about why it's not fair, and there's many other reasons. But yeah, it's also very traumatising to interact with Services Australia for many of us. Any requirement to do that is going to create a barrier to access, and people won't access it as a result.
Thank you. Mr. Bahani, does the Darwin Community Legal Service have concerns about making activities that were unlawful retrospectively legal, particularly given the pattern in Services Australia where we seem to have, I note that, we had something similar happen in 2011. We've also had robo-debt. There seems to be this ongoing pattern where Services Australia doesn't get it right and then they come back and say, oh, now it's all fine.
Thank you, Senator. This matter of income apportionment is sort of beyond the scope of our submission, but as a member centre of Economic Justice Australia, we would generally rely on their submissions in respect to that issue.
All right, thank you. I might ask you both around the new debt waiver amount going forward. It's been set at $250. There's been a number of submitters to this inquiry who've said that if you were to take the original amount when it was first instigated and apply indexation, we'd be much closer to around $440 now. And so they're suggesting that the starting point for that should in fact be closer to $440. Can I just check what your views are on that? I might start with Anti-Poverty Centre.
Yeah, sure. We don't think it goes far enough even to lift it just by inflation, because payments were significantly more adequate in the 90s when that value was set. So at the moment, if you are, trying to survive on $380 a week on the job seeker payment, and you've got a debt that you qualify for this waiver, I think there's a real misunderstanding that if your debt is less than this amount, that it just gets waived. That is not the case. You have to go through a process and prove that you're worthy to have it waived. It's not easy. So I think at the very bare minimum, it should be lifted in real terms, not just by inflation.
Mr. Bahani?
Thank you, Senator. So again, it's sort of beyond the scope of our submission. However, we would be generally supportive of anything that assists our clients with debt, including an increase to the amount that attracts an automatic waiver. We also would note that it could increase operational efficiencies for Services Australia as well.
Okay, thank you. I think I've probably got time for one more question. I guess my question would be in relation to, you've obviously given evidence from the Anti-Poverty Centre that there are people who have had criminal convictions as a consequence of income apportionment. I'm just wondering what your position is on having some of those convictions vacated if it's made clear that the evidence on which they've been convicted was in fact incorrect and unlawful.
Our position is that no one should ever be criminalised for a social security debt unless there is extreme fraud. And when I speak to fraud, I want to note that in the Services Australia annual report, they identify that some fraud is perpetrated by people who work at Services Australia. Not all welfare fraud is done by welfare recipients, and it is a very tiny number of people. You're talking a couple of dozen convictions a year. For people who have been convicted on unlawful evidence, it should be obvious that those things should be overturned. There should be no work required. As I said, the person we're working with is being put through enormous stress just to try and have his conviction vacated, is working with a lawyer who isn't super across this area, and there's very minimal access to legal assistance for this because there are too few resources, and obviously we have called for community legal centres to be fully funded. He's not even able to access a community legal centre and is going through a non-specialist lawyer.
Thank you. Do you have anything to add, Mr. Bahani, before I finish?
Nothing further from me. Thank you, Senator.
Great. Thank you. Thanks, Chair.
Thanks, Deputy Chair. I'll go to Senator Brown.
Thanks, Chair, and I'd like to thank you both for coming along to this consultation into this bill. I'll just, if I could, start with the Anti-Poverty Centre. Hello. I just, first of all, would like to go to what consultation have you done with your membership in making your submission?
Yes.
The centre's submission, I should say.
Yes, very, very difficult given the extremely minimal time, the complexity of this. Like, the bill itself doesn't do a lot of complex things, but it has a lot of interaction. So we haven't had the opportunity to do what we would like to do, which is normally go and spend a lot of time with people, having one-on-one conversations, getting their input, getting their ideas. So our submission is based on our general support that we provide to individuals. We have run it by a couple of folks who are directly affected by this, but we have not had the opportunity to do that in a systematic way because this has happened so quickly.
Oh, okay, so but you were aware that the submissions opened on the 5th of September?
We are an organisation of unpaid welfare recipients. There are a very small number of us, and we are dealing with helping people in crisis routinely. We are flooded with submissions, requirements to do submissions, and we did seek to have input or at least be able to ask questions about what was happening with this response from the government before the bill was actually introduced. So yes, we are very well aware of our capacity constraints, which is why we tried to have some input before the legislation was actually brought. It's quite a significant amount of material to review, as you might be aware.
Yeah. Well, thank you, and we thank you for coming along today. Now, do you accept that income apportionment only that income apportionment only affected debts at the margins?
It's hard to know what you mean by at the margins. In our submission, we've made clear that one of the principles the government could uphold in its response to the income apportionment case is the notion of social security law being beneficial legislation, and that therefore, if people receive a slight benefit to whatever the government chooses to do in response, that is actually part of upholding that intent, and that at the moment this bill does the opposite of that.
I just wonder exactly what is the Centre's position. Are you saying that you don't support the bill going forward in this form at all? You'd rather see it not proceed?
We feel that we're in an impossible position because we want to see the debt waiver increased, and as you noted, we have not had time to actually go out and get really clear direction from people affected by this in a collective way. And so we are not able to say to you that this bill should not go ahead, but we're extremely concerned that without amendments it is going to cause a significant amount of harm. I don't think the government should take that lightly, and it shouldn't be hard to make amendments that address those concerns.
Because we have heard in evidence today that, over 800 odd thousand people will be affected by this bill in a positive way. So I just really trying to be clear in the understanding of your position, because we have had the other evidence also given today that they see this bill in the main as doing a lot of good things and things that are needed. But you're suggesting that, can you just make it clear to me whether you would rather see this bill not go forward at all if it wasn't amended? Is that what you're saying?
No, we can't make it clear to you. That's what we're saying, is that the failures of the government's response mean we cannot make it clear to you. Waive all the debts, it's not that hard. And then, come back and do real work. We've put in our submission that there is significant amount of reform required in this area, not limited at all to the income apportionment issue, and that there has been a 2-year wait period since the government committed to the Robert Royal recommendations. There are no excuses for the lack of serious consultation. So I think it's really unfair to be pushing us to try and give you an answer when you know that it is extremely complicated for those of us who are directly affected by what's happening here.
All I want today is just to make sure that I am understanding your evidence. I'm not pushing you one way or the other. I'm simply asking a question, given that we have received evidence here today about how many hundreds of thousands of people will be positively affected. And so I'll go to Mr Bahani and ask him the same question.
Thank you, Member. Is this in regards to income apportionment?
Just about your view, I'd like to get again your view clearly on the record about the effect of this bill and the view of the Darwin Community Legal Service.
And thank you, Senator. The scope of our submission really extends to Schedule 2 of the bill. And we're very optimistic. We are in support, and we think it would have a net benefit for persons receiving social security that have a debt to gain access to relief through the expansion of the debt waiver powers for special circumstances. The only thing we'd just like to add is potentially also adding a further amendment just to remove the requirement for severe financial hardship when seeking a waiver on the basis of administrative error under the Paid Parental Leave Act and the Family Assistance Administration Act.
And they were the areas that you outlined previously.
Correct.
Yep. Okay. Well, thank you. Thank you, Chair.
Thank you very much, Senator Brown. I'll go to Senator Collins now.
Thank you, Chair.
Thank you both so much for your testimony today. My question is for Mr. Bahani. I just wanted to ask you a few questions about that particular amendment that you are advocating for, about the administrative error. Now, I'm no expert in this area, so I just want to understand what sort of administrative errors are occurring. You know, what's really happening there? What sort of examples do you have, and how many are actually in the system that are making a big impact here, or having an impact at all?
Thank you, Senator. I can only speak from experience. To Services Australia's credit, there's only 2 cases that really stand out. So the first one was a person who applied for the job seeker payment. They did the application. They made it clear that they were married. They provided their partner's income, and then they started to receive the job seeker payment and was getting it at a rate that had been provided by Services Australia. Later, they were notified that Services Australia had become aware that they were married and raised the debt against them. I can't remember exactly how much the debt was for. We did a Freedom of Information request and found the actual application where it was very clear that this person had disclosed that they were married, and they had disclosed where their partner was working and what their partner's income was. Where we last saw that client was awaiting a decision from an authorised review officer. So that's the internal review process for a debt with Centrelink. Normally you would first ask them to review the debt internally, and then once they make a decision, you would appeal it if you disagreed to the Administrative Review Tribunal. The second case involved a parent whose child went to boarding school. They were receiving ab study and family tax benefit. Early on in the school term, the child became homesick, so they changed as a day student at another school and were living with their grandparents. My client resided in a remote First Nations community where secondary school schooling services weren't available. They notified Centrelink of the change, and they were informed that no action was required, and they continued to receive the payment. Eventually, they notified Centrelink again, because that first phone call was about the ab study payment. About 18 months later, I believe, they contacted Centrelink again just to confirm whether the grandparents who the child was living with should be receiving the family tax benefit payment. And that's when the debt was ultimately raised, because they were then informed that they weren't entitled to the payments to begin with. Thankfully, the larger debt was waived due to administrative error. The smaller debt wasn't. And in the meantime, the client had made quite commendable efforts to basically overcome a lot of hardship, and they were in a position where they were no longer suffering severe financial hardship. So although all the factors or criteria for an administrative error waiver were satisfied, it wasn't granted on that basis alone.
Sure. Yeah. They're 2 pretty clear examples. Appreciate that. What if, because you mentioned that that should they should be waived regardless of whether they have financial hardship because of administrative error, and I agree with the principle of that. I can see how easily that can happen. What if reviewing it results in the fact that these recipients actually should be receiving more money? Should there not be a clause in there for that?
So would that be in relation to they're entitled to a higher rate of payment than they otherwise received?
Yeah.
Again, with something like that, I would need to see some sort of draft bill before I could really comment on it to understand how it would operate. But yeah, generally we would be supportive of that. I could understand where there could be some difficulties because typically you become entitled to a payment, a social security payment, when you make the claim for it. So if it was a difference between two different payments, so for example, you were receiving job seeker, but you were otherwise entitled to the DSP, but you never applied for it, I could see some difficulty there. So it would ultimately determine on how, it ultimately depend on how the bill was ultimately drafted. I apologise that I can't really provide anything further than that. Yeah.
You've helped me and I appreciate your explanation today. Thank you so much. That's it from me, Chair. Thank you.
Thanks, Senator Collins, and I thank you both for your evidence today. If you've taken any questions on notice today, I'm pretty sure neither of you did, but the committee will be reporting to the Senate on Tuesday the 21st of October and has agreed to responses for questions on notice that should be provided by the close of business on Thursday the 9th of October. We will be moving to the next set of witnesses, so thank you both for appearing today.
Thank you, Senator.
Thank you. I now welcome representatives from the Department of Social Services and Services Australia who are moving to the desk I can see in the room. I'll just give them a couple of seconds. Welcome. Thank you for appearing before the committee today. The Senate has resolved that an officer of a department of the Commonwealth or a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution does not preclude questions asking for explanations of policy or factual questions about when and how policies were adopted. Commonwealth officers appearing today are also reminded of the Senate order specifying the process by which a claim of public interest immunity should be raised. A copy of the order is available from the Secretariat. For the Hansard record, could you please state your full names and the capacity in which you appear today?
Thank you, Chair. Andrew Seaback, Branch Manager, International Payments and Compliance for the Department of Social Services.
Matt Flavel, Deputy Secretary, Social Security from DSS.
Bronwyn Warswick, Chief Counsel from DSS.
Chris Birra, Deputy Chief Executive Officer for Payments and Integrity at Services Australia.
Dan Blackmore, Acting General Manager of the Legal Compliance and Remediation Division at Services Australia.
Robert Higgins, General Manager, Payment Assurance Program and Appeals Division, Services Australia.
Thank you very much. I will now invite you to make a short opening statement of no more than 5 minutes, because I'm sure the committee members would like a substantial amount of time with you. The conclusion of your remarks, I'll invite the members of the committee to ask those questions. I think I'll go to Services Australia first.
No opening comments from me. Thank you, Chair.
Thank you. Department of Social Services, did you have an opening statement?
No, thanks, Chair. You've seen our submission to the committee. In the interests of time, we'll just go straight to questions from committee members.
Great, thank you. I'll go to Senator Collins first.
Thank you so much, Chair. Look, I just want to get a sense. We've got the numbers in the formal submission. 16,000 formal reviews are paused, 87,000 undetermined debts, which may be affected by income apportionment, but there's no sort of sense of the total value of the debts that we're talking about here. We've heard about, we've heard testimony today that perhaps this should be extended all the way back to 1991, but, under the what's been recommended here to I believe it was 2003. Can you just sort of give us a sense of how big this debt is that we're talking here?
Thanks, Senator. So it's Matt Flavel from DSS. So as our submission in the bill notes, the practice of income apportionment, we understand, went back to the early 1990s. It isn't possible to say with precision how many debts may be affected, because that would require going into each individual debt and seeking to determine exactly whether it was or wasn't impacted by income apportionment. We know that over that period, given the size of the social security system and the length of time, there's many millions of debts that could be potentially impacted. Within that, there are a smaller cohort, the ones you referred to, where there's matters that have been sent for review or where a review has been sought, or there are undetermined debts that relate to pre-7 December 2020 employment income. So I think it's just a sort of a long-winded way of saying it's actually not possible to be more precise about the exact numbers that may be impacted. But the bill, of course, seeks to validate the use of income apportionment, and that would apply to the entirety of affected populations, going back to the early 1990s up to effectively anybody who had employment income up till the 6th of December 2020 that would have potentially been impacted by income apportionment.
Okay, thank you. We've heard various evidence today about the debts that individuals are being asked to repay. Do you have any idea of what the average debt is per person? If you want to just sort of maybe do it on the past 3 years or...
No, Senator, we don't have, again, precise data on the average. Again, because we don't know exactly how many are impacted by income apportionment, it's not possible to say for a group affected by income apportionment, this is the average size. There are, of course, by definition, lots of much smaller debts in the system, and then a few outliers where there can be very large ones. And probably tend to think of it more in a distributional sense rather than average because of that reason. You do get, for a very large number, a long tail at the low end, and as I said, a few outliers that are very large debts as well.
Yeah, thank you. Because I really do, I do want to understand, really problem that's trying to be solved here. So, perhaps if we can get some data from your question on notice, how much of this debt is actually legitimate debt that needs to be paid back? How much is debt that actually, putting people under distress and they shouldn't have to pay, and in some cases, might have to end up being paid by the government because, it's very hard to analyse a problem without seeing those numbers in front of us. I don't know if that's a question on notice, if you'd be able to respond to.
Yep. Now, let me have an attempt, because I take the point you're raising. So based on the sampling we did, we expect that the median size of affected debts, so that's the debt size, would be about $330. Of those 5.5 million debts, about 97% have been paid off. So, people would have potentially had an affected debt in the 90s, in the 2000s, in the following decade. The debt would have been raised and they've paid it off. So very few people have an outstanding debt. That's actually a quite small number. The number we typically use is around the sort of 160,000 mark. Those are people whose debts were paused for repayment when this issue arose. The government said it wouldn't be fair to continue collecting repayments from people while the legalities are being sorted out. We also note from the sampling exercise that the median change in debt when using a non-income apportionment methodology is less than $100. And so it just gives a bit of a sense that we're generally talking about fairly marginal changes to a debt that was previously raised. Remembering all the while that what we're talking about is probative evidence having been provided in the form of payslips. It wasn't a made-up number. It was using payslip data and using a methodology that apportioned that across a couple of fortnights in most cases, as opposed to the way that the legislation should have been done. But we are talking, therefore, about deviations from a kind of that $330 median, if you like, that are relatively small.
Thank you. That is very helpful. A final question from me. We've heard some recommendations today that debts should be waived. What's your view on that?
Well, Senator, going back to what I said, 97% of affected debts have been paid off. To waive or to essentially, that would mean effectively going back and refunding millions and millions of debts going back to the early 1990s. We know from data provided by colleagues at Service Australia, the number of hours involved in doing that is significant. So a lot of and that's before you get to the impact on the individual, having to go through the process of effectively a reassessment. There's a group of people that I've already mentioned, that broad group around 160,000 whose debts are on hold. There have been arguments that that group should have been waived, but again, the methodology used there is the same as the group that previously mentioned that have repaid. There's evidence provided, and what this bill will do is validate the use of that income apportionment methodology across the entire cohort, remembering that there's a really important schedule in the bill that also opens up a resolution scheme that would be available to anybody with a potentially affected debt from 2003 up until 7 December 2020. That is where they had employment income fitting the parameters that made it an income apportioned debt.
That's great. Thank you so much. Appreciate your time today.
Thanks, Senator Collins. I'll go to the Deputy Chair.
Thanks, Chair. I might just preface my questions by saying that every time I come to estimates or these hearings, I'm really concerned about language around, $100 being relatively small. We are talking about people who are in incomes of around $350 to $400 a week. That's, for some people, that's a quarter of their weekly income support payment. So I think it speaks to a culture of where we need to really understand and appreciate the huge impact that even small amounts of money have on our most vulnerable people in the community. And I also note that we regularly hear about the fact that there's a lack of precise data or and words like that, when in fact we're expecting people on income support to be incredibly precise in a complex system, and they are never given the same level of, we have these repeated instances where the Department of Social Services and Services Australia gives themselves a free pass by retrospectively making things lawful, and we very rarely extend that same consideration to people on income support. So I guess my questions are prefaced by those observations. We've seen that this bill is identifying the period for automatic waiver provisions as being limited to 2003 to 2020, and so it doesn't cover debts from 1991 to 2020. I'm interested to know whether the department provided advice to the minister recommending that limitation, and if so, what was the basis for that advice, and were any other options put to the minister for that time period?
Thanks, Senator. Obviously, we provided a range of advice in relation to the issue of income apportionment. On the rationale for that choice of that date, there have been sort of several legislative amendments through time to the way that employment income is assessed. There's a fairly definitive set of changes that were implemented in 2003, so we can be sure with confidence that income apportionment was being applied after that date. And so the rationale is really about saying, if we know with confidence that it was being applied from 2003 onwards, that would be the cohort who would be eligible to make a claim under the resolution scheme.
And so are you confident that income apportionment wasn't being used from 1991 to 2020?
No, that's not what I said. No, that's not what I said, Senator. I referred to earlier that we understand the practice may have been used as far back as the early 1990s, noting that the current incarnation of the Social Security Act was a 1991 Act of Parliament. But it's more about the precision of knowing with certainty that it was being applied after the change to the legislation in 2003.
Okay, so you're not certain, though, that it wasn't applied before then. So back to my original question, in the advice that you gave to the minister, was that the only time period, or were there a range of options put to the minister about the time period that the waiver could cover?
Senator, as you know, the normal convention not to talk about particular elements of advice. I've already said we've provided a range of advice to the minister. If you want to go to specifics, I'll take that on notice about when and where.
If you could take that on notice,
Sure.
that would be really appreciated. And I've got a few questions that we'll put you in writing on notice just around specific numbers and things, but conscious of time, so I won't put them to you now. Can you advise, based on your current modelling, how many individuals you believe are expected to receive compensation under the proposed resolution scheme?
I might take that on notice, Senator, in terms of the specific number. We have, what I need to point out is, while we will have made an estimate, it is a demand-driven scheme. So that if whatever estimate we've made, if more people apply, then more money will be made available. It's not a scheme that's limited in the amount of dollars. It's only limited in terms of somebody's underlying eligibility for the scheme itself.
Have you done any modelling at all on what you expect the potential maximum might be?
We've done, I wouldn't say modelling, I think we've put together estimates based on an assumption of how many people might take it up. To construct that, it's probably helpful to think about, there's multiple cohorts, but at least two. There's people whose debts have been on hold, that 160,000 group, so they are people with a direct connection at the moment through MyGov and through Services Australia. I would anticipate a significant portion of those people would apply because, by definition, they're sitting on hold because of income apportionment as an issue. But the further back you go, many people, I think just the reality is many people have, lost, don't recall whether they may or may not have had a debt. Many people come into the system for a short period. They might have been a student and received student payments for a year or two, say in 2005. We don't expect all of those people will say, well, yeah, I think I had a debt and therefore I'm going to go through the process of applying. So there'll be a bit of natural sorting of the numbers with a higher proportion sort of in the system versus those who might be a bit more historical, if I can call it that.
Yeah, so in terms of, I guess I won't use the word modelling, but those estimates, what's your highest estimate to date that you think might be captured by this?
I will take that on notice. Thanks, Senator.
Okay. We heard evidence from, so we've in the submissions that we've received, we've had a number of submitters raise concerns around the aspects of this bill that retrospectively validate income apportionment, particularly with concerns around the impact on people's legal rights. When questioned today, Economic Justice Australia gave evidence that their preferred option for dealing with debts affected by income apportionment would have been to waive them entirely as a class of debts, and to use their words, but that option wasn't on the table. What is this retrospective validation. Did the department provide advice to the minister on the option of waiving this class of debts versus making income apportionment retrospectively validated, or did you only provide advice on the latter option?
No, Senator. We provided a range of advice to the Minister and the Government in relation to the potential options to deal with this issue, noting, of course, it's been sort of publicly discussed, including through estimates committees in previous parliaments for a number of years now.
Working with Women Alliance's submission recommends that the government should, I quote, ensure that accepting a payment doesn't automatically extinguish broader legal rights unless the survivor provides informed independent consent. I'm wondering if you can comment for me on what are the broader legal rights that might be impacted by individuals accepting a resolution scheme payment.
Yeah, thanks, Senator. I think it's a really important point. Nobody's review rights are extinguished through this bill. They remain. In accepting a payment, the person is obviously foregoing the right to effectively ask to have their debt recalculated using an alternative methodology. By definition, if they're accepting a payment, a resolution payment on income apportionment, that's very different than extinguishing their general rights of review. All the general rights of review that apply to somebody's debt, whether that's historical or current, are not impacted. I think to the particular issue you raised, I think there's a little bit of misunderstanding around the way that the income apportionment resolution scheme will work and the retrospective validation, none of which actually extinguishes anybody's rights, and concerns that some stakeholders, I think, have raised separately about the special circumstances waiver and how that will work, particularly where there might have been the presence of family and domestic violence as a particular indicator or factor in the raising of that debt. They're two separate parts, as you know, under this, but I think sometimes there can be a little bit of mixing. But I just want to reiterate again, nothing in the bill invalidates people's existing rights to seek a review under the Social Security Act in relation to their debts.
So, by way of practical example, we heard evidence today, for example, that there are some people who've been have debts that were calculated using income apportionment. Their debt is around about the $5,000 mark. As I understand it, based on the sampling, the average difference between income apportionment calculations and not is up to a third of that debt, meaning that somebody might have $1,800, for example, that's owing to them if their debt was calculated properly. If this Act passes in its current form, can that person recover the $1,800 or are they limited to a maximum payment of $600?
I can answer.
I'll get our Chief Counsel perhaps to speak to this one. Thanks, Senator.
Senator Bronwyn-Warswick, the Chief Counsel from the Department. As Mr Flavel explained, accepting the resolution payment under the scheme does not preclude the individual from seeking merits review or pursuing other appeal rights in relation to their debt. What accepting the payment under the scheme means is that they are accepting the payment as recompense for the use of the mechanism of the income apportionment, which we are acknowledging was an unlawful methodology for the calculation of their debt. But they can pursue other matters in relation to their debt. For example, if they wanted to seek a review around whether or not their treatment as a member of a couple that gave rise to their debt was or wasn't right, they can absolutely pursue that. They could seek review of the amount of the income assessment associated with that debt, and they could also still seek a waiver under other waiver provisions. The scheme is about remediating and responding to the issue of the use of the income apportionment methodology. It's not a scheme that overtakes or bypasses or means an individual forgoes other existing features of the social security system, which entitles them to both internal review arrangements within Services Australia and pursuing merits review and or judicial review subsequently in the federal court. There will be a release process, though, that they will be given information about when they apply to the scheme, and they will be informed of their rights. And we've spent quite a bit of time developing and thinking about how that information can be conveyed. And in our stakeholder consultations, including, and I think particularly with EJA, National Legal Aid and ACOS, it became very apparent to us that we do need to work very closely with our Services Australia colleagues to make sure that information and those explanations about individuals' rights are very clear and in the simplest and most comprehensible format, noting the range of individuals who are likely to be interacting with Services Australia when they apply for the scheme. And we've committed to going back and talking further with those groups about the nature of that communication.
Yes. Having said all that,
yes,
if I'm John Smith and I have a debt that's been calculated using income apportionment, and it's clear that on recalculation, not using income apportionment, I would be entitled, I've been overcharged $1,800. If this bill passes, what do I have to do to get my $1,800 back?
You would need to, in an initial step, go to Services Australia and apply to have your debt reassessed.
Okay, so even though we've got a system where we know that there's... And can I get if it gets reassessed, if this bill is passed and makes income apportionment retrospectively valid, can I still get it reassessed?
Yes.
To get my $1,800 back?
You can have your debt reassessed, but that will also put you through the debt reassessment process, which I think my Services Australia colleagues can explain. That will require Services Australia to look at your evidence and also do their own investigations around that debt. And the point will be for the individual that that's a separate process.
Okay, so I guess my point is we've got this scheme or this way of calculating debts over a long period of time where we are going to have people in that situation who may very well not have paperwork anymore. I mean, that's precisely what we saw during robo-debt, that people are being asked to deal with and ask for debts to be reassessed that are being raised from well outside normal statutory limitations that we would find in any other aspect of the law. And so I think what I'm hearing you say is, yet again, we have another situation where if somebody hasn't kept all their pay slips or can't get access to that evidence based on this ongoing system of income apportionment where we know there are going to be people, and the sampling told us that more people paid more than less, we're going to have a situation where it's going to be very difficult, and yet we have a compensation scheme that's capping out at $600. So I guess the point I'm trying to make is by capping it at $600 and the evidence you're giving, there are going to be people who were much worse off due to income apportionment who are going to find it very hard to recover the amount of money that they technically are owed. Would that be a fair assessment?
What I will say, Senator, which I probably should have mentioned earlier, is the bill in Schedule 1 also contains a preservation clause. And that's in clause 1117 capital C, which expressly preserves accrued rights of individuals. So what the package is giving individuals is that they have the choice. If they accept the income apportion affected debt validation that the bill will give effect to, then their recompense is via the scheme, or they have a choice where they can pursue their rights in accordance with what the bill will enact. So they're not really in any... I mean, they have the option of taking the scheme route, or they have the option of seeking reassessment and then pursuing their rights.
And Senator...
I need to share the call now, Deputy Chair, to Senator Ananda Raja. Thank you.
Thank you, Chair. Thank you all for your testimony. It's been clarifying, and for the work you do in administrating our... I'd like to go back to the beginning, and could you please summarise the changes outlined in the bill and why those changes are necessary?
Yeah, thanks, Senator. So there's a few key components of the bill. The first is the provisions that would retrospectively validate the use of income apportionment. I would say at this point it's important to remember that it's a pragmatic solution to what was, I think, a way that was kind of uncontested for many decades, actually, in the way that debts were calculated. People could have, of course, asked for reviews or pointed out that they didn't think the methodology was right. Our own investigations show that, unlike robo-debt, where it was very clear you had people shouting from the rooftops, so to speak, saying that this was illegal, nobody actually really wrote or even said anything about this. It was only that it came up several years ago, and that on investigation, the extent of it not being lawful was raised. So the validation is really, I think, a pragmatic response to that. Obviously, it was and is acknowledged as being unlawful. So the resolution scheme, as Ms Warswick said, is a way of recognising that. Again, it's a pragmatic application. What it seeks to do is to minimise the extent to which affected people have to do anything. That can be compared to, say, a situation where you do ask people to go and recalculate, and as we've heard earlier, will involve lots of work both for Service Australia and for the individual, and cause sort of further angst, and in a lot of cases just simply delay the extent to which people can kind of have it resolved. I think that there's also really important elements here that go beyond income apportionment to strengthening the way that debt management and debt processes work under social security legislation. Some of this was raised in general terms, obviously, out of robo-debt and other processes, but particularly the increase to the small debt waiver removes what otherwise is a lot of angst for recipients, often people currently on payment with limited means, who otherwise have very small debts raised, often at inconvenience to them, but also involving a fairly sizable cost to Service Australia in having to raise those. $50 is incredibly low, and as the material notes, that limit hasn't been raised since 1993, so effectively has lost a lot of its real value. And then further strengthening around the way that the special circumstances waiver operates, and this has been raised in parliamentary committees, to specifically countenance circumstances in which a person hasn't knowingly accrued that debt, and often this, but not limited to, but will often be in cases of financial coercion, etc. And again, you know, this represents a further strengthening. It's not necessarily everything that could be done, but I think that it's really important steps that seek both to deal with the issue of income apportionment and demonstrate a tangible contribution to actually improving the way that the social security system works in respect of the way that debt management occurs.
With respect to the special circumstances waiver, could you perhaps talk us through the rationale behind how you landed on the justified in circumstances language in the bill, because that's been raised by some previous witnesses?
Yeah, thanks, Senator. So we've outlined at page 11 of our submission the kind of underlying rationale for choosing that particular formulation. It is a quite conscious choice to make it subjective and to maximise the extent to which it can deal with all of the circumstances involved. The alternative would be to have, say, words like reasonable, which we think would be more of an objective test, and actually run the risk of not achieving what is sought out, what is being sought here in terms of doing it, or in some ways to remove all of this altogether, which of course would nullify situations in which the waiver might not be applied in cases, say, of genuine fraud. So we think that it's a sensible way to deal with the policy intent, which is about broadening the circumstances in which the special waiver is applied, but doing it in a way that uses that word justified as opposed to other alternatives.
Do you think that there's... Yeah, sorry, go on, Special Counsel.
Oh, Senator, I was just going to add in relation to the use of the term justified, if I may, and I know that we have addressed that specifically in our submission, and Mr Flavel referred to that, but we listened this morning in that term has been flagged by a number of groups as being concerning. Just wanted to clarify that the policy isn't designed, and the mechanism that's put in the bill isn't designed to rest on an individual or a victim survivor being able to justify themselves. That is in no way what's intended, and that's actually not a natural reading of what we've written anyway in the bill. It's more about what we're saying is we want identification of circumstances such as family and domestic violence or other situations, because it's not a mechanism that's confined to that issue as being justified. And so I just wanted to make that point because I know that that was something that people were concerned about. It's meant to be a broad-based, wide consideration for a decision maker, having regard to the entirety of the circumstances on a case-by-case basis. It's not in any way a mechanism that would see an individual having to justify themselves.
Understood. Thank you for that clarification. Do you think that there's now a pretty decent awareness both in the department and in Services Australia around financial abuse and coercion?
Yes, there is. And I should state, of course, that while this is a really important provision, it's not the end of potential legislative and policy reform. The government committed through the election to some particular measures. And through the work we do in not just social security, but particularly child support, we're working with other government departments, including Service Australia, the ATO, the Office for Women, but also with stakeholders in trying to look at further strengthening systems to prevent weaponisation and for them to be sources of abuse. It might be helpful just to pass to Mr Birra, because I think that it would be good from a service delivery perspective just to get on the record the way in which the agency actually proactively and kind of positively deals with indicators of family and domestic violence.
Thank you, and thanks, Senator. And yes, it's Chris Birra from Services Australia. The staff of Services Australia do engage with Australians every day, and often in times of difficulty. That is sort of the raison d'etre of the agency, of Services Australia. We deliver training and awareness to staff about looking for family and domestic violence and other indicators of vulnerability and to understand a customer's circumstance. I would say our officers are very good at picking up cues about what's underpinning someone's life and behaviours, and are very good at engaging with people around them. And in terms of sort of what both Mr Flavell and Ms Borswick mentioned about the justified, that's really sort of a cue to them to look for circumstances where it's justified to exercise this exemption. We do know from speaking to staff who have worked on these matters that this sort of what's proposed in the bill is very welcome from their perspective as well, because they do see sort of circumstances where people have suffered from financial abuse and coercion or other forms of vulnerability, which has led them to provide information which hasn't been correct, which has meant that they haven't been paid correctly, but that and that the provisions in this bill will provide sort of additional mechanisms by which they can get to a more fair and equitable outcome.
And Chris, are you satisfied? I guess, look, this is an ongoing process, but are you satisfied that the staff receive adequate training in providing culturally safe, trauma-informed counselling to people?
Oh, sorry, Senator. Could you say particularly that last bit again? I just didn't hear it.
Are you satisfied that Services Australia staff, because they are at the coalface, are receiving culturally safe, trauma-informed training on how to counsel people, given the sensitivities around robo-debt, that this is already a fairly triggered group of people?
Oh, certainly, Senator, and it's something that we've done a lot of in the agency, of helping to encourage that cultural journey. The reality is that since the time of the robo-debt scheme, there has been a large turnover of agency staff as well, with lots of new people coming in. But there is very open discussion of those matters. There is a lot of awareness about cultural aspects. And what draws people to work in Services Australia and to stay here is a genuine commitment to service delivery to Australians. And you really see that when you visit sort of a service centre or visit our contact centres, that the staff have that genuine interest in servicing Australians and in trying to help where the system allows people to navigate difficult points in their life. And the staff working on these more specialised debt matters are certainly attuned to the circumstances by which people find themselves in that situation, and do work towards helping people navigate the system.
I'll just draw your attention, we don't need a comment. The financial counsellors were keen on the hotline in order to access Services Australia. It's just something for you to consider going forward. I think there is merit there, given that this is new territory. My next question is around the differences. You did mention robo-debt, so did I. Can you outline the differences between income apportionment and robo-debt? And this could be for anyone in the panel.
Thanks, Senator. Everybody's looking at me, so I'll have a go. I mean, the Ombudsman has done two own motion investigations into the issue of income apportionment, and actually I think has outlined in one of those reports the fact that it's not. At a very high level, Robodebt was really taking ATO annual income information, dividing by 26, and then assuming essentially that that was what the person earned. And clearly that was not lawful, and and I think most people could have seen that it's just patently obvious a debt could never be raised using that as the only source of information. And obviously I won't go through, I mean, we've had a Royal Commission that talks about some of the ways in which people's interactions and ability to seek review and all of those things, and very obvious harrowing stories of people's experience, which is terrible and never should happen again. As I said earlier, income apportionment at its always had probative evidence when the person had a debt raised. It had pay slips. And the way that the debt was calculated was in consultation. The person had the ability to provide information. It would often be pay slips to calculate the debt. Nobody was then having debts calculated and saying, gee, I think you've got this wrong. This doesn't seem consistent with the law. Not recipients, not legal aid, not academics. And again, in Robodebt, we had academics in particular writing papers and going to conferences saying there is no way that the method being used for Robodebt is valid. So quite different in its concept. As we know, because it used probative evidence, what generally occurs is that in most situations, if you go back and recalculate using a different methodology, there's still a debt. And it's really just a question of the quantum. And as I've observed earlier, and I'm not, to Senator Ormond's point, I'm not seeking to diminish the significance of the amounts to people, but just in relative terms, the median change is $100 or less. In other words, you take the same evidence, apply it in a slightly different way in terms of the allocation across fortnights, and you get a different result. And of course, as has been noted through sampling, in some cases it would have resulted in a higher debt. In about 35 to 40% of cases, the person would have had a higher. So again, unlike Robodebt, which was everybody getting a debt which was invalid, income apportionment had people who would have had slightly higher, some slightly lower. Hence why I think the practical approach is the validation, and then also recognising the lawful or unlawful element and offering resolution in a fairly sort of straightforward and pragmatic way for people to apply.
If I may, Senator, in addition to what Mr Lavelle just mentioned, Robodebt was using annual income information. The probative evidence in this instance was generally, for most people, on a fortnightly basis. And those fortnights did align to when people were receiving an income support payment, while, of course, because of the episodic nature of a lot of people going in and out of work, the annual information might have included periods where they weren't receiving an income support payment. And indeed, in some instances, as was revealed at the Royal Commission, some people had been receiving an income support payment for only a very small amount of the financial year that their annual income statement related to.
My final question relates to the small debt waiver. I understand that will extinguish debts now for around 860,000 or so people. I would like to understand how you landed at that threshold. What was the rationale? Anyone on that?
Yeah, no, thanks, Senator. So currently there are a range of waivers, and so one of the important features is having a single waiver improves the kind of simplicity and transparency, if you will, of the system. On the level itself, the two main waivers are $50 for current recipients and $200 for those who are no longer recipients. The intuition around that was really, I think, that it cost more to recover a debt from somebody who was no longer in the system. Counterintuitively, of course, people who've left the system are often in work and actually have a greater capacity to pay. So I think that's all why, in seeking to have a single waiver, it provides more of a benefit by raising it to $250 for those currently on payment, noting that it's currently $50. And is still an increase for those who might have left. On the numbers, you've identified there's two things. There's the current people who have not yet had a debt raised will benefit from the increase upon passage of the bill. But it does also, of course, importantly, provide an ongoing benefit that it both reduces a stock of people who currently otherwise would get a debt, or they might otherwise get a notice in a year or two that they had a $130 debt, for instance. That no longer will occur at the point at which the bill passes, but importantly in each and every year in perpetuity if the bill passes, that benefit. And I think that's why I said earlier that the bill goes beyond income apportionment to recognising that there can be improvements to the way the system operates. And as I said, these actually benefit people on payment who have the least means more than people who might have left and who have a debt.
Thank you. Thanks very much. And it will be indexed, correct?
Yes, it will be indexed. And again, that's important because the previous limits were not. And so without that mechanism, through the passage of time, they lose their value.
Thank you very much.
Thank you very much. And thank you for your evidence today. That concludes today's hearing. If you've taken any questions on notice, the committee will be reporting to the Senate on Tuesday, the 21st of October 2025, and has agreed that responses to questions on notice will be provided by the close of business on Thursday, the 9th of October. I'd like to thank all the witnesses who have appeared today, also to Hansard and Broadcasting and the Secretariat for their assistance. The committee, as I said, will report on Tuesday the 21st of October and have agreed that responses to the questions on notice should be provided by the close of business Thursday the 9th of October 2025, and the committee stands adjourned.